IT people, we can't hear Honorable Manye.
Yeah, and in fact, earlier on, I even checked audio.
Honorable
Honorable
Manye,
Speaker.
please hold on. We don't hear you. We can't hear you.
Good morning, colleagues. Good morning, Honorable Speaker. I want to acknowledge that I can hear Honorable Mane.
Maybe it's us.
So do I
Okay,
hear it?
we'll try and see what's wrong with our system. I see somebody say can hear Manye is only us.
Apologies of the chief whip of the MK party.
Okay, thank you very much. Apology noted. Are there any apologies that other members have that we need to record? I don't see any hand. Thank you very much. Those apologies are noted that have just been received from MK Party. We now move to the consideration of the agenda, which is very brief, really. The report of the subcommittee on review of assembly rules, and that is the only item on the agenda. Agenda has been circulated. Honorable Manye, is that a legacy hand or a new hand?
At the new hand, Honorable Speaker. I had
Yes.
put a note on the group. I don't know, the framing of the agenda does not seem to allow for any any comment by some of us in the meeting. And I have 2 or 3 points I wanted to make in the meeting with your permission, Honorable Speaker.
Yes, after the report has been tabled, Honorable Manye, there will be a discussion. We apologize that maybe it is not put there categorically, but I just want to assure you that after the tabling of the report, there will then be a discussion. Is that okay?
Thank you very much, Speaker. No, that's fine.
All right.
Once between twice shy. One time I was asked which item on the agenda am I talking on, so I'm trying to avoid that.
No, thank you very much. That is noted. Thank you, members. Can I get the mover for the adoption of the agenda?
I move, Honorable Speaker.
Honorable Manu moves. Can we get a seconder?
I second, Honorable Speaker.
Thank you very much, Honorable Direct. We now move to the report of the subcommittee on review of assembly rule. Subcommittee chairperson, can you please make a presentation? The report was circulated to all members. It can also be flighted. Thank you.
Thank you very much, Honorable Speaker. Good morning to you and my colleagues on the platform. I'll request that I switch off my video for better connectivity. So I will go straight to the subcommittee report. I hope I'm audible, Honorable Speaker. The report is straightforward, and also I will not go through the proposed rules as they are. When I come to that, I'll request the technical team to deal with that, Mr. Tasso and Perry. Thank you very much, Honorable Speaker. I believe that I'm audible. The subcommittee on the review of the Assembly rules was established in terms of the National Assembly Rule 197 to provide advice to the National Assembly Rules Committee, the Rules Committee on the Rules and Orders of the House. On the 8th of May 2026, the Constitutional Court, the court handed down judgment in an application brought by the Economic Freedom Fighters and the African Transformation Movement, case CCT 35/24, regarding the report by the independent panel, the panel established by the Speaker to assess the evidence in a motion submitted in terms of Section 89 of the Constitution of 1996, read with the Assembly rules concerning an incident at the private premises of the President of the Republic of South Africa. The Constitution, the court determined that National Assembly Rule 129I was inconsistent with the Constitution and invalid. The court also invalidated the vote that took place on the 13th of December 2022 in the National
Honorable
Assembly.
Speaker,
Yes, Honorable Mhlauli.
my sincere apology for disturbing Honorable Mpapane. The chief whip of the largest party is on the waiting room and is not being accepted. It's been long now. I thought that by now he will be accepted. My sincere apologies.
Okay, thank you. We'll ask IT to check on that. Honorable Mpapane can proceed.
Thank you very much, Honorable Speaker. The court determined that National Assembly Rule 129I was inconsistent with the Constitution and invalid. The court also invalidated the vote had on the 13th of December 2022 in the National Assembly on the report of the panel and referred the report to the impeachment committee established by the Assembly rules. In respect of a remedy, the court found that a limited severance coupled with a read-in was necessary to correct the rule, this to remain in effect until the National Assembly corrected the defect in the rules. On the 11th of May, the Speaker referred the judgment to the subcommittee to consider the implications for the rules and how any procedural shortcomings should be resolved. The subcommittee convened on the 21st of May and the 4th of June, respectively, to deliberate on legal advice and proposals, as well as submissions from political parties on the possible procedural reforms. The proposals were presented to the subcommittee by Parliament's Constitutional and Legal Services with assistance of the Senior Counsel. Two proposals were presented: amendments to the general rules contained in Rule 129A to Rule 129Q, attached hereto as Annexure A. B. Detailed rules concerning proceedings in the impeachment committee, Annexure B. The amendment to the general rules. They need to review the Assembly Rules 129A to 129Q emanated from the observations and orders of the Constitutional Court. Having considered the judgment and the proposals contained in Annexure A, the subcommittee agreed to the proposals with two amendments: the insertion of the term fit and proper into the amended Rule 129A, sub 1, in paragraph 13 of Annexure A, so that the rule will read: the impeachment committee consists of the number of fit and proper assembly members that the Speaker may determine, subject to the provisions of Rule 154, provided that all parties in the Assembly must be represented. The subcommittee agreed that this amendment remained subject to further legal advice on the term from Parliament's Legal Services. The omission of the proposed amendment to Rule 129M sub 5, paragraph 21 of the annexure, subject to further advice as indicated above. The final proposed reformulation of Rules 129A to 129Q are provided in Section E of this report. Detailed procedures for Section 89 Committee of Inquiry. In addition to the general rules, the subcommittee discussed the need for detailed procedures to regulate the proceedings of impeachment committees, Annexure B, On this point, the subcommittee agreed that the proposed procedures should be conveyed to the recently constituted impeachment committee for further consideration. During deliberations, a legal view was expressed that any such procedures should be derived from law and should be subjected to public involvement insofar as they would apply to affected persons and office bearers. There was also a view that the recently constituted impeachment committee should proceed with its business without undue delays. The recommendations to the Rules Committee. The Subcommittee on the Review of the Assembly Rules recommends that the National Assembly Rules Committee adopt the amendments to Rule 129A to 129Q as contained in Section E of this report and convey the proposed detailed procedures for impeachment committee to the recently constituted impeachment committee to consider within the context and requirements of the law and the rules. Such referral include party submission made to the subcommittee. Honorable Speaker, I will therefore, through you, request the technical team to then deal with part 3 of the report. I thank you.
Thank you. Can we ask Mr. Klasu?
Thank you, Madam Speaker, and good morning to honorable members. I will now deal with the adjustments made to the rules. I'll only highlight those aspects, honorable members, that have been adjusted.
Why?
So on Rule 129A, the only insertion there is on that paragraph 1, where it says call for the removal of the president from office in terms of Section 89(1) of the Constitution. The original rules said initiate proceedings for a Section 89 inquiry. So that wording has been adjusted. The rest of that rule remains the same. We then move to Rule 129B. Yes, so it's the same there, calling for the removal of the president from office in terms of Section 89(1) of the Constitution. Just that small technical adjustment. And Rule 129C, sub-rule 1, we have replaced the only insertion there is towards the end of the sentence, established in terms of Rule 129D. That is the insertion there. The previous rule would have said established for the purposes of considering preliminary Section 89 matters. So that's the only adjustment. And of course, on 129D,
It's cancelled.
yeah, where it says conduct a preliminary inquiry, we've replaced any. The previous rule said any preliminary inquiry, and we've said a preliminary inquiry. And on Rule 129P, is the same as the original rules. There have been no adjustments there, honorable members. And Rule 129F, again, is the same. There have been no changes. Rule 129G, 1A remains the same. And B of that, we have this insertion calling for the removal of the president from office in terms of Section 891 of the Constitution. We've also adjusted what we had in the original rules was 90 days, was 30 days. It is now 90 days. In fact, even with the panel that we had in 2022, that 30 days was increased. I think it was increased to 90 days. So we now have 90 days, which has been taken at a reasonable time to process a matter of this nature. Now on C Roman figure 2.
So we can
We'll just make that small correction there. The inquiry, it will start with the E, inquiry, not inquiry. So we'll make that technical adjustment there. And then the rest of that 129G remains the same, with no adjustment on the members. Now, we now move to 129I. This is the read-in emanating from the Constitutional Court. So this section has been completely adjusted because the 129I in the original rules required that the report of the panel should go to the assembly. So it said that once the panel has reported, the speaker must schedule the report for consideration by the assembly with due urgency, given the program of the assembly. The president must be informed and all of that. So the court said, no, we must not go that route. Once the panel has reported, the speaker must inform the assembly of the report. The president must be provided with a copy of the report forthwith. In the event the panel concludes that sufficient evidence exists as contemplated in Rule 129G, the matter must be referred to the impeachment committee established by Rule 129J for a Section 89 inquiry. Rule 4 says, in the event the panel concludes that sufficient evidence does not exist as contemplated in Rule 129G, the speaker must schedule the report for consideration by the assembly. And in the event the assembly nonetheless resolves that a Section 89(1) inquiry be proceeded with, the matter must be referred to the impeachment committee established by Rule 129J for a Section 89 inquiry. This has been taken from the court order as is, that is the 129I. Then 129J, we say the Section 89 inquiries. Now the original rule said impeachment committee for Section 9 inquiry in a singular. So this one says inquiries. Then 129J, 129K, one of the members. This is where the fit and proper comes in. So this proposal is saying that the impeachment committee, and these are other adjustments, where it just said committee, the committee, these rules say the impeachment committee. They are specific that we're dealing with the impeachment committee. Consists of the number of fit and proper assembly members that the speaker may determine subject to the provisions of Rule 154, provided that all parties in the assembly must be represented. Notwithstanding 155(2), the members of the impeachment committee must be appointed as and when necessary. Members will be aware that there's since been a legal opinion on this matter, and with the guidance of the Honorable Speaker, that opinion will be presented, and then we'll take it from there. But this is what comes from the sub. Committee must, when the assembly has approved. So we've taken out that leg. It goes straight to the impeachment committee must proceed to establish the veracity. We now move to Rule 129O, honorable members. I'm not dealing with the others because they remain the same. 129N has not changed. 129O, Rule 2, the impeachment committee must contain findings regarding the charges in the motion calling for the removal of the president from office in terms of Section 89 of the committee, and a recommendation as to whether or not the president should be removed from office, including the reasons for that. And then Rule 129P, the assembly may reconsider, and if so, it so decide, alter a decision taken by the speaker in terms of Rule 129K. Now, 129K deals with the composition of the impeachment committee. So this rule says that the House has the ultimate say or final say on the composition of that committee. But if it wanted to adjust the composition as determined by the Speaker, it must do that within 5 days of the taking of that decision. And then sub 2, the Assembly is bound by a conclusion in the report of a panel that sufficient evidence as contemplated in Rule 129G. This is a new rule. And the reasoning here is that the committee would have applied itself, would have listened to witnesses, gone through all the evidence, and they reached a particular conclusion. And therefore, the House may not review that conclusion, that sufficient evidence exists, because the House would not have been involved in that verification of the evidence at the level of the committee. Now, 3, again, the Assembly is bound by a finding in a report of the Impeachment Committee regarding the charges in the motion calling for the removal of the President from office. Again, that is a new insertion. The same reasoning obtains here, that the committee would have gone through the evidence, listened to the witnesses, and came to a finding, a particular finding. Now, 4 says the Assembly is not bound by a recommendation in a report of the Impeachment Committee as to whether or not the President should be removed from office, provided the Assembly may vote that the President be removed from office in terms of Section 89 of the Constitution, only if the relevant report of the Impeachment Committee finds that one or more of the charges in the motion calling for his removal is established. This is consistent with procedures in respect of reports of committees. Members may be aware that sometimes the House amends a recommendation in the report of the committee, but the House never amends the text of the report. So this is consistent with that, and the fact that it is the House that must take a decision on the removal or otherwise of the President from office. 129Q, if the President is removed from office, the benefits of the President must strictly be dealt with in terms of the relevant provisions of the Constitution. That has not changed. It remains the same. Honorable Speaker, that is my presentation. Thank you so much.
Thank you very much, Mr. Castle. There is the report, but I would ask Mr. Castle if legal services can deal with that one matter of the legal opinion that was requested by the subcommittee. Is it Advocate Jenkins who will deal with it, or who?
They will guide us. Colleagues?
Legal services?
Legal services?
Good morning, Speaker. My name is Michael Prim from Legal Services. I will be dealing with the opinion.
You can go ahead.
Good morning, Speaker. Good morning, honourable members. We have provided the committee with a detailed opinion based on a request from the subcommittee that Legal Services considers the legal ramifications for the inclusion of the phrase fit and proper into Rule 129K1 of the NA rules. With your permission, Speaker, we will just provide a high-level summary of that opinion, unless the committee wants us to take you through the detailed opinion. So the legal questions that we considered, Speaker, was whether the NA is constitutionally empowered to introduce a fit and proper requirement for committee membership, whether such a requirement would withstand constitutional scrutiny, particularly in light of Section 19 of the Constitution, which deals with political rights, and Section 36 of the Constitution, which houses the limitations clause, and whether, as a matter of institutional design and democratic principle, such a requirement is appropriate in the context of parliamentary committees. Now, we concluded, Speaker, that the Assembly is constitutionally empowered under Section 57 to regulate committee composition and may introduce a fit and proper requirement. However, we cautioned that such a requirement would limit the political rights protected by Section 19 of the Constitution. And it's for this reason that we said that a fit and proper requirement, should it be inserted, must be rational It should be clearly defined, and it must be able to be justifiable under Section 36 of the Constitution. We argue that a vague discretionary standard would risk arbitrariness, and constitutional invalidity. It may also be at odds with the political and representative character of parliamentary committees. Furthermore, we caution that such a requirement should be subjected to proper consultation, as these requirements will affect both members of the NA and the public. We further held that while it is legally permissible, the insertion of a fit and proper requirement in Rule 129K1 should be approached with cautions for the reasons that we mentioned earlier. We provided an alternative approach, and we suggest that for Section 47 of the Constitution could be amended to add the fit and proper requirement to the grounds of ineligibility to become a member of the NA. We also informed the committee that there is currently a private members bill that deals with Section 47, it's been introduced recently, that deals with the eligibility requirement in Section 47, and it adds further categories. And we felt that that could be an apt place to include a fit and proper requirement as well, as it will have more general application than to insert it in a rule that deals with a specific committee. Thank you, Speaker.
Thank you, Mr. Prince. We can now open the platform for discussion. We thought it was important to have this legal opinion as part of the report so that we can deal with all of these matters at once. Honorable Manyi, I see your hand. Honorable Throlip, Honorable Chungu, Honorable Michalakis.
Okay, thank you, Honorable Speaker. Thank you for the opportunity to make submissions to these proposed reformulations of rules from 129A to 129Q. Without any further ado, there are only 4 points I wanted to raise, but just 1 point before I raise that. On the composition of the Section 89, that independent panel, the involvement of a judge there, I don't know whether it's deliberate to leave it as just judge, or we should say retired judge, or do we envisage a situation where a judge that is in service can also be part of this panel? I was not sure. So I would have thought that this is done by a retired judge, but the current composition does not make that qualification. So I just thought I should ask for clarity on that one. But on the substantive issues, Honorable Speaker, I have 4 points. But first one on Rule 129A-C, 129A, paragraph 1, subsection C. It is our view in the MK that sub-rule improperly narrows presidential accountability. Rule 129A, subsection 1, paragraph C provides that the charge must relate to an action or conduct performed by the president in person. So, Honorable Speaker, this limitation does not appear in Section 89 of the Constitution. So, actually, as it currently stands, it is inconsistent with the Constitution. Presidents exercise constitutional authority through ministers, advisors, officials, members of the security services, and other state functionaries. Constitutional accountability, therefore, cannot be confined to conduct physically executed by the president. The president may authorize, direct, facilitate, knowingly tolerate, or benefit from unconstitutional conduct without personally carrying out the final act. So the proposed wording creates a loophole whereby a president may evade accountability simply because the conduct was executed through subordinates or intermediaries. So the MK party therefore submits with respect, Chair, the Honorable Speaker, that the rule should recognize conduct attributable to the president, whether committed directly or through persons acting under the president's authority, instruction, knowledge, or for the president's benefit. So that's the 1 point, Chair. The second one, Rule 129M fails to require the president to appear personally before the impeachment committee. We hold the view, Honorable Speaker, that the proposed rules afford the president the right to be heard and represented by a legal practitioner. We, however, argue that a right to be heard is not the same thing as an obligation to account. So Section 89 inquiry is the most serious accountability mechanism available against a sitting president. It therefore concerns the possible removal of the head of state for serious constitutional violations, serious misconduct, or inability to perform functions of office. It is therefore difficult, Speaker, to justify a process in which a president facing possible removal from office is not required to appear personally before the committee entrusted with determining these allegations, unless I've understood that wrong. But the current impression created is that representation by legal practitioners could be the one way of a president being heard, and that's it, and he may not appear in person. So we make a submission, Honorable Speaker, that the rules must be explicit, that a president has to appear in person. We say representation by legal practitioners may assist the president, no problem with that, in protecting his or her rights, but legal representation cannot substitute personal accountability. We make this point very strongly, Speaker. If ordinary citizens, public servants, DGs, members of the Chapter 9 institutions, and other public office bearers may be required to appear personally when their conduct is scrutinized, there can be no principled basis for exempting the president from the same obligations. Surely, in terms of the Constitution, we're all equal before the law. The rules should therefore expressly require the president to appear personally before the impeachment committee, subject to all applicable constitutional protections. At that point, Chair, Rule 129K, which has been spoken to, introduces an undefined and potentially problematic standard. The proposed rule requires members of the impeachment committee to be fit and proper. The phrase is undefined. Without objective criteria, the provision becomes vulnerable to subjective interpretation, arbitrary application, and potential political manipulation. A constitutional process of this magnitude cannot depend on vague standards that may be interpreted differently depending on political circumstances. The NK party therefore submits that the phrase should either be removed entirely or be accompanied by objective, transparent, and reviewable criteria. We think this is quite a complicated, this could complicate the situation, Speaker, because we must then also, I think if you read that legal opinion, I must first of all commend it. I think it's a sound legal opinion because it makes a whole range of points. One of the points the legal opinion makes is that then, depending who must make the decision that a person is not fit and proper. Is it the speaker? Is it this committee? Is it the court? Or who makes it that decision? The court on its own, I would submit that it is fit and proper. But can this committee, for instance, make that decision of fit and proper if itself has not gone through that criteria? Whoever makes this decision, you know, Speaker, without digressing, the best way of putting this thing, I can only put it in Xhosa, that ayikwazi ukwenzeka ntoba ingcibi ibe iyinkwenkwe on its own. You know, it's impossible. Awukwazi kwaluswa ingcibi eyinkwenkwe and all of that. So first of all, ingcibi himself must go through the process. So Chair, for us here to sit and be in judgment of fit and proper when ourselves not going through that, I think is a problem. So I really think my clear recommendation is that I think we should reject this that submission because it will be political. The last point, Chair, rules. Last point, Rule 129P3 and 129P4. It is a well-considered view as MK Party that they undermine the constitution.
We are losing the member now.
Yes, Honorable Manya, we've lost you. We'll give you an opportunity to come back on that other last rule. Honorable Trolip. Honorable Trolip.
Yes, thank you very much, Speaker. I have two questions, and then, I'm not sure when we should comment on Honorable Manyi's presentations, but I would like Mr. Kaso to flout Rule 129P1 so that I could ask a question about it and get clarity. My question is around 5 days, within 5 days, on Rule 129P1. And then my second...
Sorry. Okay, there it is now.
Yeah. The Assembly may reconsider, and if it so does, alter the decision taken by the Speaker in terms of Rule 129K1, provided that any such alteration must be made within 5 days of taking of the decision. Now, what decision are we talking about? And have those 5 days not relapsed according to the composition of the committee? I just need clarity on what we're talking about in 129P1, please.
For you, Madam Speaker. This rule, Honorable Trolip and honorable members, is not really meant for this committee, for this instance. It's a general rule applicable to impeachment committees. Now, at a practical level, it means that once the Speaker announces the names of the members, within 5 days, if the House, in its wisdom, think that that decision needs to be reviewed, it can reconsider it. But I want to emphasize the horse was bolted on this one. So it's really not about this particular impeachment committee. Thank you.
All right, thank you very much, Speaker. So that is actually essentially my question. The horse has bolted. Then on section 129 P4, could I please get an explanation about that? Because in 2 and 3, it states categorically that the Assembly is bound by the finding of the report and that the Assembly may not change the report because they haven't had the benefit of listening to all the evidence in the committee. 4 seems to contradict that. Could I please get a better explanation than the first effort? Thank you.
Thank you, Madam Speaker. I will also ask my colleagues from legal services to assist in this instance. I think the point here, Honorable Trolip, as I said, firstly, this is consistent with current practice in terms of committee reports, that the House may not review findings of a report. The House may not review the conclusions of a report, but the House may review a recommendation of the report. But also the decision to remove or not to remove the president is for the House. It is for the House to take that decision, and the House cannot be bound by a substructure in terms of that ultimate decision of removal or not removal of the president. But as I indicated, my colleagues from legal services may want to just comment on this matter as well, but that's really the position. Thank you.
I'm covered. Thanks very much, Speaker. I've got clarity now.
Okay, thank you. Honorable Noluchungu.
Thank you very much, Speaker. Greetings to the people on the platform. Mine is on Rule 129M, which has been extensively covered by Honorable Manyi. I don't want to waste the time, but I'm comfortable with how he has presented 129. And then coming to 129K, we accept and agree with the legal opinion and that the DA in their proposal would be inconsistent with Section 47 of the Constitution. And we want to emphasize that the DA, if they really want to push for that amendment, they would have to seek a constitutional amendment first before anything can be done, or we accept their proposal. That is our input on those two rules, Speaker. Thank you very much.
Thank you, Honorable Tlangwini. Oh, sorry, Honorable Mkhalakis, and then Honorable Tlangwini follows.
Thank you, Madam Speaker. Madam Speaker, first let me point out with regard to the legal opinion that it does indicate very clearly that this is within the powers of the National Assembly to include the words fit and proper, and we welcome that finding of the legal opinion that this is totally permissible, despite the fact that the legal opinion does caution. I just want to provide clarity in that regard with specific reference to Section 47 of the Constitution. Now, the idea behind the inclusion of fit and proper is not to replace Section 47 of the Constitution. 47 of the Constitution refers to membership of the National Assembly. That is not what we are dealing with here. We are dealing with the membership of the Impeachment Committee. And I want to quote and agree with Honorable Manye, where he said that this is the most serious accountability mechanism against the President in Parliament. And that is what makes the Impeachment Committee different from just an ordinary portfolio committee, in that it requires members of this committee to have a higher ethical and general standard than just a normal portfolio committee. There are two problems, in my view, with amending Section 47. The first one is that it would take a lot of time. We do not have time right now, and constitutional amendments take a lot of time. And also, it would, in general, exclude a lot of members who are eligible to serve in the National Assembly from serving as representatives of the people. That is not what we want to achieve here. What we want to achieve is to ensure that, as Honorable Manye says, the most important accountability mechanism against the President in Parliament is something that has a higher ethical standard. And that's why I would argue that including fit and proper in these rules is the appropriate place to do so, Madam Speaker. Just on that point further, if I may just further argue that the Constitution allows Parliament to make these rules. There's nothing in the Constitution that prevents the inclusion of fit and proper, as the legal opinion says. That provision will not deprive any political party of a seat. So if a member is found to be not fit and proper, that does not mean that the party involved has fewer seats on the impeachment committee. Let's take the MK, for example. If they had 3 seats and one member is found to be not fit and proper, the MK will continue to have 3 seats on that committee. So no political party is deprived of representation. And as I have mentioned, Madam Speaker, the impeachment committee is not just any other portfolio committee within Parliament. It is actually should be held at a higher standard. Madam Speaker, just in closing, I would agree with Honourable Manye where he says that they are happy with the inclusion of this, but on condition that it's defined in a way that sets out what is objective, transparent, and reviewable criteria. I think that might be a possible solution. But with regard to the provision of fit and proper itself, I do think that it has been sufficiently defined through precedent in the courts and is therefore well and properly defined already, and that requirement is not necessary within these rules. Thank you very much, Madam Speaker, and I would, for those points made, argue that we continue with the inclusion of fit and proper. Thank you, Madam Speaker.
Thank you, Honourable Tlangwini.
Thank you very much, Speaker. Greetings to you, greetings to all of the colleagues. and staff members. I think the chief whip of the EFF was clear on our position on fit and proper. And Speaker, if we go with this fit and proper, how do we determine who is fit and proper? Because all of us will now have to be vetted to serve in this impeachment committee by the end of the day, if we are saying fit and proper. By virtue of us being members of parliament, it's already stated that we are fit and proper to do work of parliament. So it can't be that we put a rule in separate to that what the constitution are saying. But then I want to check, Speaker, on if they can go to, I think, section 89 in terms of the evidence leader that needs to be appointed. We are of the view as the EFF, and we have already wrote to you, Speaker, in this regard, that the evidence leader must be appointed in the impeachment committee, and then it must be nominated names that will be put in the impeachment committee. It must not be appointed somewhere in some office. The impeachment committee must have a say as to who will be the evidence leaders, and will assist them with the work. Thank you, Chair.
Thank you, Honorable Nhlanhla. If I may just clarify on that one, I think that issue is covered on the rules that will be sent to the impeachment committee to look at. So these ones don't deal with the issue of the evidence leader. It's just the general rules of section 89, as it were. But I'm sure when the parties in the impeachment committee look at all of those procedural issues, they will take the issue you're raising into consideration. Honorable Thandiswa Makau.
Thank you very much, Honorable Speaker. Greetings to you, colleagues, and the technocrats. Honorable Speaker, I would like to fully support what Honorable Manyi alluded to as per the Rule 129A, subsection C, which provides that the charge must relate to an action or conduct performed by the President in person. As we all know that the President has got his subordinates in his office who usually takes the mandate from him as per the delegated powers. So constitutional accountability, therefore, cannot be confined to conduct physically executed by the President. The proposed wording creates a loophole, really, whereby a president may evade accountability simply because the conduct was executed through subordinates or intermediates. So I fully support that the rule should recognize conduct attributable to the president, whether committed directly or through persons acting under the president's authority, instruction, knowledge, or for the president's benefit. Lastly, Honorable Speaker, the Rule 129M fails to require the president to appear personally before the impeachment committee. As we all know that the Citizens Public Service Director Generals, everyone, is appearing before any structure put in place. When their conduct is scrutinized, there can be no principal basis for exemption of the president from the same obligations. The rules, therefore, should expressly require the president to appear personally before the impeachment committee, subject to all applicable constitutional protections. Those are my two suggestions supporting Honorable Manyi. Thank you, Honorable Speaker.
Thank you, Honorable Makau. Honorable Breitenbach.
Thank you very much, Honourable Speaker, and good morning to all the honourable members. Honourable Speaker, I am largely covered by the input of Honourable Mikalakis. I just wish to add one or 2 points. Firstly, that the National Assembly has the broad constitutional authority under Section 57 to regulate the composition of its committees. And in the legal opinion, it's set out as that it is legally permissible for the National Assembly to introduce additional criteria for committee membership, including a fit and proper requirement, and that this should not be unfettered, we all agree on. Honourable Speaker, I would urge members to consider that the Impeachment Committee is not just any ordinary committee. It is a committee that is put together to perform really the most important function that a committee in Parliament could perform. And that we should remember that there will be a very high bar for our participation in this committee, and that there will be a huge amount of public interest. So the requirement that the members of the committee should be fit and proper would be rationally connected to the objective of promoting integrity, enhancing public confidence, and ensuring credible impeachment proceedings. And this is vital. The proceedings must be viewed by everybody concerned, the members, the president, and the broader South African population as being credible impeachment proceedings. That is vital. And so I would urge, Honourable Speaker, that we give serious consideration to including the fit and proper requirement in these rules. Thank you, Honourable Speaker.
Thank you, Honourable Direko. Honourable Manya, you'll come back last for your last 1 point.
Oh, okay, Speaker, accepted.
Thank you, Speaker, and greetings to honourable members. Speaker, Honourable Mikalakis had partly covered me. Honourable Manyi indicated that the phrase should be properly defined, making reference to the term fit and proper. He even asked whether it is us or the court that has a legal mandate to make a determination on the matter. And we hear the argument, and these matters appear to be a bit complex, and we should therefore not rush them, as we may end up back in court again, which is something that we really do not want. That is why it is important for us to make sure that any issues with gray areas are properly dealt with accordingly. Perhaps, Speaker, what we could also do is to allow parliamentary officials more time to further engage on the matter and ensure that all our resolutions are within the law. And furthermore, Speaker, this process should not only focus on the affected member, but rather on all matters of interest that may have a legal and procedural implications for the Parliament. So I therefore request that at least we allow parliamentary staff to do more proper and further consultation in this matter. Thank you, Speaker.
Thank you, Honourable Manyi.
Yeah, thank you, Speaker. Yeah, okay, yeah, apologies. I think I don't know why I lost the line there. And I've heard some of the iterations by Mr. Tasso, and I'm not persuaded. So let me just redo my point again, Chair. I'm saying 129P3 and 129P4 undermine the consequences of a proven misconduct. This is very important. A proven misconduct. 129P3 provides that the Assembly is bound by the committee's findings regarding the charges. 129.4, however, permits the Assembly to vote not to remove the President. I mean, that already becomes rational. Even where serious misconduct or a serious constitutional violation has been established. This means that Parliament may accept that a president committed impeachable conduct and yet allow the president to remain in office. I mean, Speaker, this is just not making sense. Put differently, the rules contemplate a situation where serious misconduct is proven, but no meaningful consequences follows. This is what the Constitutional Court was trying to deal with. This is why, as we sit here today, the Assembly hasn't got the latitude now to do this. We're now reintroducing that with a back door. The Assembly in the original settings, before the intervention, the progressive intervention of the Constitutional Court, the Assembly could make a political decision from an objective report of an independent panel, and they could interfere with the political decision. We're doing exactly the same thing here. Now we're doing this now, no longer with the Section 89 independent panel of Justice Sandile Ngobu. We're now doing it with the impeachment committee. Was saying impeachment committee, we can prove something that no right.
Help us with your proposals.
I beg your pardon, Speaker?
No, I was saying, having made your analysis, what are you proposing should be in the rules?
So what I'm proposing, Chair, here is that the thinking about 129P3 and P2 must also be the same thinking and rationale applied to P4. We must be bound as the Assembly by because what you'd have, Chair, in the impeachment committee is a lot of technicalities, a lot of objectivity, a lot of law is going to obtain there. So it's almost like a quasi-judicial of sorts that's going to happen there. So once that committee makes a decision to say there is an impeachable conduct here, the National Assembly must not have the option to say, we hear you, but we're going to do something different. No, we must be bound by that recommendation. That recommendation must be almost like must be a binding recommendation, just like you have recommendations of a public protector. So I want to argue, Chair, that the submission by Mr. Klaso to say just like other committees is not making sense. This should be like you have a public protector who would make binding recommendations. So this impeachment committee must have powers like that. Once they make a recommendation, that recommendation must be binding, Chairperson. That is my submission, Chairperson. Then the last point, maybe then, Chair, on the fit and proper. I was going to recommend that because a lot of work must go into this. I see the rationale for fit and proper. Really, I think it's an important thing. But the objective issues and all of that, I think it will delay and frustrate the order of the Constitutional Court. So therefore, I'm suggesting that for this round, let's proceed without fit and proper, but in parallel, can that be worked out and cleaned out and all the objective things be done, and then we can process it at a later stage. But it mustn't be a condition precedent to what we're doing now. That's my submission, Chair. Thank you.
Good morning, Madam Speaker, and good morning to all colleagues on the platform. And thank you very much for the opportunity. No, Madam Speaker, I'm largely covered on the comments I wanted to make, so I will be very brief. Firstly, I want to propose that we adopt the rules as recommended by the subcommittee. That's number one. Number two, just briefly to weigh in on the discussion with regard to the fit and proper. I am unable to pick up a contradiction between what is contained in the rules and what is suggested by the legal opinion, in a sense that we should deal with the rule for what it is as a matter of principle and not associate it with a specific individual. And that will address the concern raised legitimately by Honorable Ntlangwini, that then therefore there must be an interpretation of what we mean by that rule if it is codified in that way. My understanding is that that is a function of a different process. To build a principle and agree on it is one thing, which I think is what we need to do. And to then implement that principle or interpret it in order to ensure that there's compliance is a different process altogether. So my own view is that, and I listened very carefully to both Honorable Manyi and Honorable Michalakis, even in areas where they are converging and in areas where they may not be converging. Because I'm not a member of a sub-rules committee. I wanted to have a clear benefit of where are the areas of divergence in case they exist. And my sense is that there's more convergence than divergence. I think Manyi is raising a matter that is raising the timing question, whether this should be a matter we decide now or this should be a matter we refer to a different process for the future, which is a process, not a principal question. So that's why I'm saying I think it would be it would be better, in my own view, that we adopt the principle in its current form, and through relevant platforms in Parliament, we deal with interpretation whenever the matter arises and requires an interpretation in the course of our work. Thanks.
Thank you. Honorable Mika Mhlauli.
Thank you very much, Speaker, and greetings to yourself and all those in the platform. I largely agree with the Chief Whip of the largest party on the submission he just made. And I will make additions on the principle and not the processes as a point of convergence. But I want to make this point before that Speaker, if you have noticed, people who spoke the most and longest in this meeting are people who serve in the sub-rules committee. And the sub-rules committee is supposed to deliver this report for the consideration of the rules committee. Otherwise, we may as well have it as one committee, because if we are going to deliberate at the sub-rules committee and come here, bring the same arguments that we lost that side, it's going to be a problem. And I'm not saying you are not entitled to speak, but let's regulate and give others who are not part of the sub-rules to ventilate on what we are bringing to the committee, instead of starting afresh as if we are not coordinated. The main point I want to speak on is this one of fit and proper. You know, Speaker, it becomes very difficult when Honorable Mani says he understands the rationale. His problem is the process which may delay and which culminate into frustrations, his frustrations. Unfortunately, frustrations are personal, and we can't make rules on personal aspects. We need to follow processes and agree on a principle that says fit and proper is needed, is a principle. How do we define fit and proper? I'll give you an example of what we are going to find, which was a frustration and made Parliament not to be looked at as a institution that is respectable. You know, at the ad hoc committee, one time Honorable Adams is questioning witnesses. The other time he's being questioned because he's an interested party there. Same happened to the honorable member from the DA. How do we then have rules not to have such people in a committee where there are also persons of interest? So let's agree that this fit and proper will cover us in dealing with that, and then go and apply our mind to say, what would be the definition of this fit and proper? But we adopt the rules as they are to cover certain aspects that may arise as a problem in the future. I don't see any contradiction in adopting the rules as they are presented, especially that paragraph. But maybe we say let's go and apply our minds on what would entail fit and proper. Thank you very much.
Thank you, Honorable Vessels.
Good morning, Honorable Speaker and colleagues. Thank you for the opportunity. Let me also associate myself with what the Honorable Ntuli said, and I want to second the proposal that we adopt the rules as proposed. I also want to support the fact that we include the principle of fit and proper. There is a definition, as the Honorable Mikalakis pointed out, already set in our courts, and we must agree, and I think we have agreement on the principle thereof. Speaker, then I just want to allude with regards to Rule 129P4, which has been spoken on a lot. And I think it's about understanding the whole process correctly. The Constitutional Court found that Parliament acted incorrectly and unconstitutional to vote on the recommendation of the independent panel with regards to impeachment. What does impeachment mean? Impeachment is not removal, Honourable Speaker. Impeachment means a state of accusation. So the process is that the panel has to find if there is prima facie evidence of the grounds set out in Section 89(1) of violations of the Constitution, gross misconduct, and so forth. Then the Constitutional Court ruled that if that prima facie evidence is there, impeachment continues. That means that the president is then, as is the case now, placed in a state of accusation. But the removal in terms of Section 89, we must go back to the Constitution. And what does Section 89(1) say? The National Assembly, by a resolution adopted with a supporting vote of at least 2/3 of its members, may remove the president from office in terms of the grounds. Thus, we cannot, in any circumstances, have a rule that says that the recommendations by the committee on if the president should be removed or not should just be accepted and not voted upon. That would be unconstitutional. Section 89(1) is very clear that the removal, not the impeachment is now a de facto fact. The president is impeached. He's placed in a state of accusation. He's in front of the committee. The committee then makes findings. But the Constitution says the Assembly must vote upon it. And a vote is a democratic process. It must have support of at least 2/3 of its members. And we cannot make rules that is contrary to that. So as it stands there currently, Rule 129P4 as proposed is 100% in line with what the Constitution says, and it is not contradicting 129P2 and 3, because those are findings. Recommendation on if the president should be removed is something that should be voted on by the Assembly as per the Constitution. And thus, there's nothing wrong with the rule as suggested. And once again, Speaker, I suggest that I propose that we adopt it as such. Thank you.
Thank you, Honourable Trollip.
Thank you very much, Speaker. My first effort was at clarity, and now I just want to make some comments about the various proposals. First of all, as far as fit and proper is concerned, Action SA believes that we should be doing everything in our power to ensure that our representatives on panels, especially important committees like this one, are fit and proper. So we have no problem in principle around getting a proper definition of what is fit and proper. I think this is what the public of South Africa expect of members of parliament, for us to do the right thing and to be fit and proper. But I also want to refer to the section that Honourable Wessels has just spoken on now, who I think gave the most coherent explanation about it, because I want to remind the Rules Committee that it was due to unfit and improper conduct by the National Assembly that we find ourselves where we are today after the Constitutional Court ruling, where this Assembly and the majority of the members in the Assembly simply voted to protect somebody rather than to hold somebody to account. Now, that is unfit and improper. But I think what Honourable Wessels has done is certainly covered my concern around 129P4, because the Constitution makes provision for the Assembly to vote on impeachment, on the findings of an impeachment committee, whether to remove the president or not, and we can't delegate that to a committee of 31 people. That would not be constitutional. So I'm happy with Section 129P in its entirety. When it comes to Section 129A and 1C and 129M, as per Honourable Manyi's representation, Action SA is in full support that the president must be held accountable for what he does in person and what he does through direct and indirect involvement in any improper conduct. I fully support that. The president has influence beyond what he himself or she himself does. They do influence members of the executive, they influence government, and they certainly influence VIP protection teams and various other people. There is influence that goes with the office. So the president should be held accountable for his direct and indirect actions. And then 129M, I believe that the president should not be shielded from appearing before the committee by sending a representative. Of course, he's entitled to have representation, but the president should appear in person. So I support the input from the MKP around those two items. The rest of the items, fit and proper, and 129P, 1, 2, 3, and 4, we support. Thank you, Speaker.
Honorable Manyi.
Yeah, thank you, Honorable Speaker. Thank you for your indulgence. Yeah, I've heard and I've listened very carefully to the submissions by other members as well. I wanted to just check, Chair, what this means, because if you read the legal opinion, first it talks about things that are not going to apply retrospectively, as it were. I just needed us to be clear on this, as to we should be at it in terms of what the entirety of that legal opinion means. And as I said before, that I think the Comrade Mtumseni really also summarized it very well in terms of separating issues. That the issue here, the principle of fit and proper, I don't think anybody should really argue with this principle. It's a very important principle. My problem was the fact that because I don't like it, we can't say we accept the rules as they are with a fit and proper. Whose fit and proper has not been defined. We don't even know who's going to determine it and all of that. That was my problem, that if we make it applicable here and now, it means that we must first know what we're dealing with. We can't say accept as things stand on something that is not defined. And I don't quite agree with Honorable Michalakis when he says it's a defined rule. If you go to the legal opinion again, the legal opinion talks to this matter. It says that the fit and proper incident that we had in Parliament had a specific situation, and the situation was about appointing other judges. Here, the legal opinion is very clear that this is not the same thing here. Here we're dealing with something else. We're dealing with members of Parliament that are doing oversight. So it's a totally different context. So the two can what happened in that situation cannot be transposed here. So therefore, the fit and proper is not a general term that can be used under general application. No, it's not like that. That's what the legal opinion says. So I'm saying, Chair, Honorable Speaker, with respect, that if we proceed with that understanding of Honorable Michalakis, will be actually going against the legal advice. The legal advice is clear that the term is not general, it is specific. And this is my issue now, that to say, for us to make it Section 89 specific, it's going to require some work. And when we do that work, we will inevitably frustrate the Constitutional Court order, which talks to immediacy, as it was. So we need to find a happy medium here. This is why I was suggesting that. And I thought on the chief whip of the largest party was correct in separating issues. And that separation of issues, for me, it would then amount to that for the rules that must be adopted for here and now, so that the impeachment committee can go through unhindered. We must remove fit and proper, but we're not removing it forever. We're removing it for now so that everything else to provide certainty. But on the background, then all the work of the objectivity and customization and all of that can happen. That can take months for that piece of work to be done, because there's going to be representation and all kinds of things, Chair. So I'm saying, Chair, I think the statement to say adopt the rules as submitted is shortchanging us, Chairperson. Let's remove it for now and deal with it in parallel or in sequence or parallel or something. But it can't be. Asikwazi ukuthenga ikati isengxoweni, Chairperson. We cannot have a situation like this. We cannot agree to a fit and proper which is not defined. If we leave here on Thursday, we say the rules have been approved, they've got a fit and proper, what does that mean? And as I'm saying that the submission by Honorable Michalak is shortchanged, is defeated by the legal opinion, which says that term is not a general term. It's a term that is specific to a situation. And the legal opinion, Honorable Speaker, is clear. It talks to the issue directly to say it's not transposable. It's in the legal opinion. So why do we pretend here now that it is a general term that is transposable? That's my submission, Chairperson. And I welcome the support also by Action SA on the other 2 points that were raised. And I don't know if, Chair, we are going to talk to the issue of the retired judge or judge or whatever, just so I'm clear on that one, Chair. But my recommendation is that we should be clear that it's a retired judge that we're talking to. Thank you.
Thank you. Is there any other honorable member whose hand I might have not seen? No, let me ask Council and Legal Services to respond and I'll conclude.
Thank you, Madam Speaker. Maybe on the issue of Rule 129, 129A-C, our response would be that if that rule were to be changed, it would not apply retrospectively. It would be for future engagements. In any event, such a change would require that this be referred back to the subcommittee. When the rules were formulated originally, I think the options were kept open to go for a retired judge or a active judge. And I'm not sure that it is really necessary to be prescriptive there. Hence the need to consult the Chief Justice. The Chief Justice would advise on whether a particular judge can be released to attend to this matter. So there is that safety measure where the Chief Justice will be able to advise Parliament. My colleagues from Legal Services will comment on the issue of fit and proper and what are the implications of either of the options being given through you, Madam Speaker.
Thank you. Mr. Prince?
Thank you, Honourable Speaker. As we stated in our legal opinion, it's permissible to include the requirement of fit and proper. We would, however, advise that such a requirement would require public participation because of the significant implications of introducing an additional requirement such as that. And in addition to that, proper consultation also among stakeholders, which is political parties, before we introduce a requirement like fit and proper. But whether it's permissible or not, we are of the view that it is permissible in terms of Section 47, in terms of Section 57, to introduce such a requirement. Thank you, Speaker.
Thank you, honorable members. And the issues have been canvassed and also responses have been given. I do think, though, that there is just one determination then we must make. I think everybody agrees with the principle. However, the concern is its applicability now. Secondly, the other concern is adopting it without clear definitions as to what it means. And the third issue is what is raised by legal services, that it's a matter that might require public participation. And on the basis of that, I think as this committee, we then need to make a determination as to whether we believe that we go ahead with it as it stands in the rules, or we send it back to the subcommittee, or we remove it until we've canvassed it, have public participation on it before we can bring it back to the rule. Can I get a response from members? Honorable Ntuli,
No, thanks, Speaker. Just
Honorable
before,
Michalakis, and Honorable
yeah,
Zwanele.
okay, just before one can comment on the substance of what is being said, Madam Speaker, as you know, I'm a relatively new member of Parliament. I may need to be educated on what the legal person is saying. Which of the rules are we required to make as Parliament for our own internal work that require us to go to a public consultation? Which one are not? And how does the determination get made that you can't make that rule without going to the public for your own internal workings as Parliament? I just want to understand that, because I think we can't deal with the substance of what we are suggesting we must deal with now unless there is clarity, in my view, on that aspect. That's what I wanted to raise for now.
Thank you. Honorable Michalakis.
Thank you, Madam Speaker. I fully agree with Honourable Ntuli on the public participation requirement specifically. I do not think that this is something that we have done, at least as in my time on the Rules Committee, on any of that. We have accepted submissions, but we haven't, in the time that I've been here, taken any rules to public participation. Apart from that, also the definition of fit and proper is a matter of legal precedent. So the courts have already defined it, and we have, to a very large extent, already clarity on that. What we need to do is we need to use the definition as set out in the courts. I would argue that to send it back to the subcommittee or to remove it subject to public participation at this point would be irrational and would delay the matter unnecessarily. I would very strongly argue that we proceed with this and that we use the already established legal definition of what fit and proper is. Thank you, Madam Speaker.
Thank you, Honorable Manye, followed by Honorable Tlangwini, followed by Honorable Breitenbach, followed by Honorable Mahau.
Yeah, thank you, Honorable Speaker. Speaker, also I just need clarity on your side as well, whether you're going to go through some of the points one by one, or like, for instance, we're doing fit and proper now, because then I also need to make sure that the other points that one had raised, you've captured them properly in your summary as to what's going to happen to them. For instance, the response by Honorable by Mr. Klaso was a bit vague in my understanding on that 129A1C. And we feel very strongly as MK party on that point, that you can't have a situation where a president is going to do things through other people and be clean. And this must not be personalized. We're just talking principle here. Can't have a situation like that, where, I mean, the president is head of cabinet, has got at least a minimum of 34 people that do things on his behalf. And so if you do something believing that you've got the support of the president, and when the chips are down, then all of a sudden you've got a holy president that has got nothing to do with that. I mean, that doesn't make any sense whatsoever. So that 1C must go, Honorable Speaker. On this issue of the fit and proper, our clear recommendation, Chairperson, with the options that you've given us, is that remove it for now. And for the reasons that the legal services has articulated. And I think Honorable Michalakis is holding on to his point, despite the legal opinion saying that the definition is not generic. It is the situational, and he does not want to accept that. And his recommendation is premised on his understanding, which is an incorrect understanding, that fit and proper is defined. And the lawyers are saying fit and proper is situational. The opinion says that in that particular case we've had in the National Assembly, it was as it pertained to the appointment of judges. That was one set of issues. Here, it's a different thing. We're doing oversight. It takes a different meaning. And for that to happen, I can even understand and accept the issue of public participation and all of that, to say what should it mean for this, because it's going to be, this is an unprecedented step that we're doing now. We're doing this impeachment process for the first time. So I would sympathize, I would actually agree with the legal opinion that for that process to unfold, public participation must be part of the process. So Chairperson, and that's why for me, I'm saying I'm not in disagreement with this noble principle of fit and proper, but we need to arrive at it objectively. And the process outlined by the legal opinion is, in my view, correct. Let's have it, what is this rush for here? Let's have the process properly rolled out.
On a point of order, Chair.
And all agreed.
Point of order, Chair.
What is the point of order? Honorable Manya, can you hold on? What is the point of order?
Chair, I'm confused what we are doing now. Are we reopening the same discussion we're having? I thought you asked a question and we need to respond to your question. The only thing that was remaining was the clarity that Honorable Ntuli looked for so that we can deal with your question. The reopening of who is right, who is having a wrong understanding and all of that, we will go back and respond as well because we're listening. So I don't know what we're doing. I'm a bit lost. If you can give clarity on that.
Okay, Honorable Manya, members are responding to the question that I'm making. Yes, they may be advancing their points and supporting them, but it's answering the questions I've raised. Thank you. Honorable Manya, you can proceed.
Yeah, thank you very much, Honorable Speaker. Yeah, I think, in fact, actually, I concluded my point. As I said, that I thought the Honorable Ntuli had summarized it very well to say maybe it's a timing issue, and I agree it's a timing issue. The principle of fit and proper, nobody in his right mind would disagree with that. But the problem right now, timing issue and the process to arrive at it. And I accept the Speaker's summary as well to say we can't be basically agreeing to a principle which is not defined. So let's define it thoroughly and let's go through the process that the legal advice is suggesting. But for now, clear recommendation, remove. Thank you, Honorable Speaker.
Honorable President.
Thank you, Honorable Speaker. I disagree quite sharply with Mr. Prince's view of public participation, Honorable Speaker. There is no such requirement whatsoever that there should be public participation in the internal policies of Parliament. And I disagree completely that this process requires public participation or should be opened up for public participation. The legal opinion states quite clearly that the National Assembly has a broad constitutional authority under Section 57 to regulate the composition of its committees, and that it is permissible for the National Assembly to introduce additional criteria, including fit and proper. So I disagree very sharply with that opinion, and I do think that is a completely unnecessary process and should not be considered. Thank you.
Thank you, Honorable Shauli.
Thank you very much. Thank you very much, Speaker. In responding to your question, first, I think that we must adopt, especially the fit and proper as proposed, and deal with the other matters that pertain to that at a later stage while we have adopted. You know, the question that Honorable Ntuli is asking and what Honorable Breitenbach is disagreeing with, I think they are correct. They have point. You know, when we came out of elections, Honorable Speaker, the second largest party was the Democratic Alliance. They decided to join Government of National Unity. We did not go for public participation to say MK party is now an official opposition because it's not in Government of National Unity. We did not go for public hearings when we said Honorable Ntuli is not going to be a chief whip of the majority, is going to be a chief whip of the largest party. So there are things and examples of what was done internally which did not go for public hearings that ourselves have determined, and they become rules in the National Assembly. The latest being that of order of speaking in Parliament. It did not need public participation. It needed us to make our own rules. So public participation, we would really need to be convinced for what at this point. If that can be clarified before we speak on the other issues, but on the first issue of fit and proper, let's proceed and not be guided by feelings now.
Thank you very much, Speaker. Speaker, I think our position as the EFF it's clear. I will propose as that the rules stand over and it's properly canvassed as the legal advisors have advised us. Has advised us. I think it needs to be taken out because as we have stated earlier on, we don't agree with the rules in the way it's being put down, and it dampens on the constitutionality of being a member of parliament. Now it must be determined, each committee must be determined by the speaker who is fit and proper. And I think that on its own, it dampens on our constitutional right and even the rules of parliament that indicate that all members of parliament can participate in whatever committee of parliament. So I think for now, let it stand over. Let's get more clarity on it, and maybe perhaps change the wording as per this fit and proper, because it's very problematic. Who do we determine who is fit and proper? By virtue being sworn in by the Chief Justice, it's already an indication that you are fit and proper. It's even stated in the Constitution as what it means to be a member of parliament. Now, if we are putting another fit and proper, tomorrow you are saying we must go and do health assessments and all of that, because you are determining we must do fit and proper. You are saying tomorrow what is fit and proper? All members of parliament must have a matric certificate. That is also, how do you determine this fit and proper? What is the criteria? Who is fit and proper? And that is why we are having a problem with this word of fit and proper. Let's all go and write assessment tests to see that we understand the constitution of the country to be able to be a member of parliament. So I really want to plead with you, Speaker, to let us put it aside for now, or and look in terms of how we can tackle this portion of the rules to ensure that we are having the correct candidates in this impeachment committee. Thank you, Chair.
Thank you, Honorable Ntuli.
Speaker, I thanks. I thought before I come back, I was going to get a response from Mr. Prince, because I asked the question.
Okay, let me ask Honorable Prince or Honorable Castle.
Yeah. Madam Speaker, maybe I should just say the following. Of course, my colleague will come from the legal side of things. When we did a review of the Assembly rules in 2016, we did invite public inputs on the rules. And of course, one must indicate that we don't always do that. And we were basing that on Section 59(1), the NA of the Constitution. The NA must facilitate public involvement in the legislative and other processes of the Assembly and its committees. So we based it on that. But as members have said, in between now and then, we have not always gone to the public, and it's a really case-by-case matter that happens on a case-by-case basis. So maybe my colleague can explain, but also the issue of retrospective application of this. Mr. Prince will deal with that matter. I thought, ma'am, I had answered Honorable Manyi, but just so that we remove any doubt. I said that if you wanted to amend 129, well, remember, this is not a consequential amendment. These rules are largely about consequential amendments with a few exceptions. If you wanted to amend 129 AC, you would need a substantive process, and that would mean it must go back to the subcommittee on the review of rules. And the issue of an obligation to appear by the president before the subcommittee, I think it was indicated that the detailed rules are going to the subcommittee. To the impeachment committee, and the impeachment committee must grapple with those issues. That's not what we are dealing with here. Fit and proper, that's what is being discussed at this point in time. So I thought we had responded to Honorable Manyi in those terms. Thank you, ma'am. Mr. Prince, may you want to come in?
Mr. Prince, do you want to come in on the public participation issue before Honorable Ntuli comes in?
Yes, thank you, Chair. Madam Speaker. Madam Speaker, I appreciate the views of members. Our view, and this view was supported independently by two senior counsels that we've canvassed these views with. Our view is that Section 57, as well as Section 59 of the Constitution, makes it clear that the National Assembly may make rules and orders, and those rules and orders must have due regard to, amongst other things, public involvement, is what 57 say. 59 says the National Assembly must facilitate public involvement in the legislative and other processes of the Assembly and its committees. And it's our view that this form part of what is referred to as other processes of the Assembly. Now, I cannot speak for the way rules were adopted in the past, Madam Speaker. All I can say is, maybe in answering Honorable Ntuli's question, is that we need to distinguish between process issues and substantive issues. And it's our opinion that mere process issues, as determined by the rules, does not need to be subjected to broader public participation. But where the rules seek to amend or introduce substantive issues, like this concept of fit and proper, it is our view that this will affect not only current participants of the Assembly rules, but also future members. And we feel that if members do not feel that broader public participation is required here, at the very least, internal consultation with members is required, although our view is that this is a matter that should be subjected to public participation. Thank you, Chair.
Thank you, Honorable Ntuli.
No, thanks, Chair, and thanks to Mr. Prince for the clarification that he has provided. And I do note as well that he doesn't want to take responsibility for what had happened before his arrival. He makes a comment that I don't want to talk to what happened before. But unfortunately, this is Parliament. It can't run on the basis of us who are here today. It is running on the basis of rules, precedents, and all that has happened. And with due respect, I don't agree with him as well that all other things that we've decided and inserted on our rules as Parliament since then were merely operational and administrative things. It's only now that we are faced with what he calls a substantive changes on our rules. I don't agree with that. That is his opinion, and I have a different opinion to that. We said here earlier on, through some of my colleagues, I never said this, but I listened to them carefully as they were saying this. Honorable Mani, Honorable Mkhalakis, and others, just to paraphrase them, that this is an extraordinary responsibility before the National Assembly. For the past 30 years, we've never had to deal with a situation where there must be an impeachment of a sitting president. It's an extraordinary responsibility. It has come one in 30 years. It therefore follows that for such a responsibility, there would be higher expectation of our population, from our population. And the higher expectation will justify the position that says, therefore, even as we are sitting at home and we are watching developments in the National Assembly, you should be absolutely comfortable as a citizen of this country that the members who are seized with such a fundamental responsibility meet the requirement of being fit and proper in undertaking that responsibility. So I don't think that when we say this must be inserted now, it must be part of our rules. We may have to wait for another 30 years again to discuss impeachment of a head of state. So when we say we agree this must be inserted now as part of our rules, we are in no way suggesting, Speaker, that therefore the work of the impeachment committee must be delayed. We're just agreeing on the rules. The impeachment committee must continue, but it must continue with adopted rules, which include the fact that members of that committee must be fit and proper. If and when it occurs that a challenge arises which requires an interpretation as to whether any of those who are members of the impeachment committee are fit and proper, let's deal with that issue separately, with the work of the impeachment committee proceeding. Like I was saying earlier on, matters of interpretation should not be conflated with matters of principle. And I want us to do away with the notion that says, if we insert this in the work of the committee or in the rules of parliament, we are blocking the work of the impeachment committee. I don't think that is the intention. The intention is that there must be an established principle, and we must work on the basis of that principle as we undertake the responsibility assigned to those who are members of the impeachment committee. That is the point I wanted to make, Madam Speaker. Thanks.
Honorable Mkhalakis.
Thank you, Madam Speaker. Madam Speaker, I firstly want to align myself with the input just made by the Chief Whip. Madam Speaker, I think it would be rather disingenuous of parties to ask for a postponement if you consider that the subcommittee sat last Thursday. It's Tuesday today. It's almost a week later. We all come to these meetings quite well prepared. And that is why we asked for the legal opinion, is so that we can get clarity in order to be in a position to make that decision today. And I do think that we should proceed in making that decision today. That's the first point. With regards to retrospectivity, we must also bear in mind that we are making rules not only for this particular case, but also for the future. And I therefore think that the addition of this would make a contribution in that regard. Just finally, Madam Speaker, with regard to the membership of the NA itself and the public participation, firstly, I think that those questions will open a can of worms that we can't necessarily contain, because the question then arises, are all the rules that Parliament has made to date where we didn't have public participation all of a sudden invalid? I don't think that is something that anyone can agree to. Internal consultation is done. Ultimately, every member in the House has a vote on these rules, and that is a form of consulting the members whether they agree with it or not. But, Madam Speaker, the most important point that I want to make is this, that despite the fact that almost anyone, except those excluded in the Constitution, Section 47, can become a member of the National Assembly, not anyone can become a member of all committees of Parliament. Not any member of the National Assembly can become a member of the Intelligence Committee. Not every member of the National Assembly is eligible to become a member of the Ethics Committee. So there is precedent on this, that certain committees do exclude certain members on a certain basis. And that is the exact same exclusion that would apply here without having to amend the Constitution. The impeachment committee does and should have a higher standard of eligibility to serve on it for very particular reasons. And therefore, I don't think it is necessary for us to ask the question whether the Constitution should be amended, because there is precedent that not all members are eligible for all committees of Parliament. Thank you very much, Madam Speaker.
Honorable Trolley.
Thank you very much, Speaker. I just wanted to put on record that I was concerned when Mr. Tasso responded to my issue around 129A and 129M about the President being responsible for matters directly and indirectly and appearing in person. Mr. Tasso basically said, you know, this can't be retrospective and that it would have to be considered for the future. We are convening here to discuss the rules and changes made to the rules and the inclusion of issues such as fit and proper and issues and changes that arose from the Constitutional Court ruling and judgment. Therefore, nothing should be off the table, and I thought his comments were unfortunate. Otherwise, we're wasting our time here if we can't change the rules. And I want to reinforce the fact that I think the President should be held accountable for his actions, both directly and indirectly. And there's no provision that prevents that. And then secondly, I think it would be important to ensure that the President does appear in person. And I just need clarity from you whether the comments made by Mr. Tasso are valid, because otherwise, if they are, everything we've done here this morning would be moot as far as his comments are concerned. Thank you.
Thank you, Honorable Vessels.
Thank you, Madam Speaker. I think it's important that we don't leave the comment or the advice, so to speak, on public participation with regards to rulemaking just open. We should conclude on it because it does make our rules that we have made in the past and will be making in the present. Our rules are a living document, our rules and orders, vulnerable and susceptible to contestation on that count. Madam Speaker, with all due respect, I think it's a misinterpretation of Section 57(1)(b) of the Constitution to say that the constitutional provision obligates or makes it compulsory for public involvement with regards to rulemaking. On a plain reading of Section 57(1)(b), it is clear that that is not the intention of the section. The section says, make rules and orders concerning its business, comma, with due regard to representative and participatory democracy, accountability, transparency, and public involvement. On a plain reading, that means that the rules should keep in mind that public involvement should be facilitated in Parliament. The rule should not limit public involvement. The rule should allow for public involvement. It does not say that when we make rules, it should be made by going out on public participation on the rules that we make. That is not what Section 57 is saying. And also the interpretation of 59 on other processes. I think that is a very limited interpretation of the Constitution. And Madam Speaker, I think the record should be set straight. We've never gone out on public involvement or public participation, rather, when we've amended the rules or made the rules in any instance. And I don't think we should follow that advice in terms of this process, but also other processes. And Madam Speaker, my opinion is still that we can include fit and proper without any further processes. It's a principle and there is a clear definition of what it means. There is the precedent that there is a higher standard with regards to certain committees, and this, all members have expressed themselves that this committee should have an higher standard because it is of a greater significance and importance, and thus the limitation of eligibility of a member on this committee is, in terms of the limitation clause of the Constitution, rational and proportional to the purpose of such limitation. And I think it would stand the test of a constitutionality test in terms of the limitation clause. And I thus once again support the inclusion. Thank you, Chair.
Thank you, Honorable Manye, followed by Honorable Mahawu and Honorable Tlangwini and Honorable Noluchungu.
Thank you, Chair, for your indulgence. Chair, I think the first thing is that I think can you request the lawyers to settle the matter on whether fit and proper is defined or fit and proper is situation specific, because we seem to be at odds with some of the members here in terms of that. So that's the first point. Can the lawyers settle that legally? Because we've got the legal eagles right here. Can they settle that? I hold the view that fit and proper is not defined, as is argued by Honorable Michalakis. It's situation specific. Can we clear that? Because that is the nub of the issue at one instance. That's the first thing. Secondly, Chair, I think it's courts generally deal with what is before them. And what was before the court was the vote of the National Assembly and all of that. Now, if we had taken a whole bunch of rules for the court to reflect on them, I'm sure the court would have also spoken to this Rule 129A1C. And I would be saying, Chair, the process that we're doing here, I align myself fully with the sentiments expressed by Honorable Trolley Pierre, that when we do what we do here, we should go beyond the code of duty to do what is right, to capture the letter and the spirit of the court. The reason we are entertaining the fit and proper here is not ordered by the court. So let's not pick and choose what you want to do here. Let's do everything as it were. Fit and proper is not ordered by the Constitutional Court. It's something that we think in the spirit of the court or something, we must do that. So I'm saying, Chair, that in the spirit of being consistent with the court in terms of accountability, the principle here is accountability. If you want to leave 129A 1C as it currently stands, it means this parliament is actually reneging on its duty of ensuring accountability. You can't have a situation where a person with authority can exercise his authority through other people and be left scot-free. That chairperson cannot make sense. So I'm saying that 129(1)A must be removed or reworded to make sure that it is there in person, and even when we're doing rule amendments here. So we have to actually do that, chairperson, and make sure that things that are tributable to his decision must come back to him. We always say the CEO carries the buck. Now, why in this instance we want the minions to be the ones that are dealt with? I mean, it's really not making any sense at a governance level, even, chairperson. And then the other point, Chair, briefly, I think the legal, I think the reading of that section 57 by Honorable Vessels is, with the greatest of respect, it's actually very limited. It's actually incorrect. The heading, that's not the chairperson of section 57, says internal arrangements, proceedings and procedures of the National Assembly. This is about how we do things, where we hold meetings and all other processes and whatever you. The lawyers have explained this, that this is what this means, that what we're doing here, we're not dealing with that kind of a thing of where we're going to hold meetings, what processes are we going to do, what is the representation. Those are all the things that are meant here in terms of this thing. Court has got also its own uniform rules of how they do their internal matters. Here, we're dealing with a substantive issue of amending the law. Basically, this is what we're doing, how to impeach a president and all of that. And even this internal arrangement does not take away transparency and public involvement. It is even here, that thing, Chair. And for members here to pretend as if it's a nice to have, the issue of public involvement is problematic. And Mr. Klaso has been clear as well that actually in 2016, when the rules were done, public participation was there. The fact that this parliament, parliament from time to time needs it's actually quite embarrassing that we have a National Assembly that from time to time must be told what the right thing to do by the courts. Here, at least now, we're all awake now. We are saying we may not have done it here and there, but now we are awake and we're saying we must not do it consciously. Other things maybe can be excused that maybe we didn't do them, it was unconscious, there was no malafides and all of that. But right now, this is actually a malafides space, Chairperson. We want to, with open eyes, just commit a crime. This is what we're doing here. We've got a legal opinion. We want to take a view that we reject the legal opinion, but we've got no other legal opinion that contests this legal opinion. And we are told that this legal opinion was also not Advocate Prince's creation. He had his own mind, but he consulted two other senior counsels. But we don't have anything that matches that, simply because we are spirited in what we want to do. And we say, no, we reject. No, Chair, this cannot work like that. I think we should respect the legal opinion. It is well-founded, Chairperson. And again, in conclusion, submit, Chairperson, that fit and proper is not ordered by the Constitutional Court, and therefore, not that we discard it, but for what we are doing now, it can wait the other processes of public participation as advised by the legal eagles, and so that we have something that is solid. We can't have something agreed to in the rules that is not defined. That is just a no-no. We don't know.
Honorable Manya.
Yeah, we don't know who decides. Is it the speaker that's going to decide? Is it the court that's going to decide? Who is going to decide this thing, Chair? So we can agree to that, Chair. Thank you.
Thank you, Honorable Mahau.
Thank you very much, Honorable Speaker. My point, Honorable Speaker, is around public participation. Now, my view is that everything which will lead us to public participation, we must try to avoid, knowing exactly the length, the long processes of public participation. And secondly, there were submissions up by members of certain rules that will result to a process which is not free and fair. My point and my proposal, Honorable Speaker, is that if possible, the subcommittee must assist us, as you have recommended, that must we bring maybe other things back to the subcommittee. If the subcommittee will assist us in terms of reviewing some of the submissions of the rules, let it be, that is my recommendation, that let the subcommittee come in and assist us in terms of relooking at the rules which were submitted here, in terms of having a free and fair process at the end of the day. Thank you, Honorable Speaker.
Thank you, Honorable Sangwini.
Thank you very much, Honorable Speaker. First, Speaker, I think it's disingenuous to say that members of this committee didn't prepare whatever inputs that they have put in front of this committee by the Honorable Mikalakis. It's disingenuous from him. And then secondly, Speaker, I think we were quite clear that let's put this rule aside, because how, and I was not answered earlier on, how do we determine what is fit and proper? the Honorable Michelakas would know, to be in the Intelligence Committee, there is a vetting process. So are we saying that members of the Impeachment Committee must go for vetting and a clearance, and clearance by whom? So those things need to be clearly identified, because you can't just say they must be fit and proper. Fit and proper is determined by whom and by what. But must they have some law degree to be in the committee? Must they be healthy? And all of those. What do we mean by fit and proper? Must they be able to analyze rules and all of that? Must they be able to investigate the people that will come in front of the impeachment committee? So the way it's standing, it's really not giving us a full indication what is this fit and proper. And to state that we must not go for public participation, it's yet again a disingenuous advice. Because if we continue in the rules in this format, we will be left with no options yet again to run to the courts and go and so that they can determine for us what is this rule of fit and proper. What do we say who is fit and proper to be in this committee? Because what is fit and proper according to us for a member of the impeachment committee? Members must not be having or allegations of fraud and all of that. Let's state it and put it out in the clear. What do we mean by this fit and proper? Because as it stands now, even in the sub-rules committee, we were not fully canvassed. What does it mean to be fit and proper, Honorable? That's why we are coming to bring it back to say, let us know what is this of fit and proper. Must members go and write an assessment? What do we determine by fit and proper? So in its current form, Speaker, I will plead with you, let's get another legal opinion, but let's not put it for now into the rules. Thank you.
Thank you. Honorable members, thank you very much for...
You have not you've noted my hand, but you have not allowed me to speak, Speaker. May I?
Oh, sorry. Honorable Noluchungu, sorry, ma.
No, thank you very much, Speaker. Speaker, I think we should avoid a situation where parties will run to courts to get our problems or our misunderstandings interpreted by courts. We've had to do things our own way after we had been given advice. Now we had asked for a legal opinion, and it is stated here that this legal opinion that is being presented here, it was in consultation with other two senior counsels. And yet here we are arguing with them and saying there is precedence. And we are not taking into account that precedences had led us into courts. So I want to plead with you, Speaker, that if we are then guided by principle, let us go back and allow the president to come and answer before everyone, and not being principled on certain matters and not being principled in matters where we have personal interests. I therefore ask you and plead with you to be partial and make the right decision. Let us park this and proceed and not adopt these rules with a fit and proper that is still not.
Noluchungu, we're missing you. I think Honorable Noluchungu was summarizing, but was kicked out, I think, by the system. When she comes back, I would recognize her just to conclude her point. Honorable members, I've listened to the discussions and very strong views that have been made by the respective members on a number of things. And I would like us to start with Honorable Manye, you have heard your point.
Yeah, no. I've made, but the only thing, Honourable Speaker, I had asked, so that before you summarize, Honourable Speaker, I had requested that can we have the lawyers settle the issue of whether fit and proper is defined, because that is the nub of the issue. So if, with your indulgence, Speaker, if you could just ask them to just, before you summarize, can they put this matter to bed of whether it's defined or not defined?
Thank you. Legal Services.
I'm going to hand over to my colleague, Ms. Isaac, to address that issue, Madam Speaker.
Thank you, Chairperson. With regard to the question as to whether the term fit and proper is defined, we have quoted case law, and there's also other cases in which there is a general meaning to what fit and proper is. However, that definition is usually used in respect of public office bearers and professions such as legal professions. Currently, and that definition is, of course, context specific and depending on the nature of the profession and the requirement as to why a particular role or person has to be fit and proper. Currently, obviously, the rules do not define what fit and proper is, and therefore there needs to be a common understanding for the National Assembly as to what fit and proper means. How does it apply? To what particular conduct will it apply? For instance, does it apply to previous conduct? Does it apply to conduct committed during a member's term? So we don't have a common understanding as to what fit and proper means in respect to members of the National Assembly. Thank you, Chairperson.
Thank you very much. Honorable members, I have listened to the various points that members have raised and other questions of clarity, but also where members have raised very strong views on what the rules need to address. Firstly, it's important for me to indicate that not all parties are part of the sub-rules committee. There are 8 members of the sub-rules, but the rules committee include everybody. Yes, all parties were given the rules to make their comments. Maybe others may not have done so. I just thought it's important to clarify that first. Secondly, there are other issues that have been raised beside the fit and proper. If I were to start on what Honorable Mpapane raised, is that these amendments have largely been occasioned by the Concord ruling. So that's where we start first. But in the exercise of that work, it was in the view of the subcommittees that there might need to be clarity given on other points, which is why you will see that there may be other new insertions that
Losing the speaker.
Starting with 129A, C. The point was raised by...
Speaker, you disappeared for a minute there. If you could just retrace your steps.
All right. I just want to say that there are other issues that in the work of the subcommittee were actually included to strengthen our rules or to align them, which may not have directly come from the Concord's judgment. There are also issues that have been raised strongly by other members. Maybe not everybody commented on them. For instance, 129A, 1 subsection C. Honorable members, some of them are actually arguing that that point should be expanded to also deal with other subsidiary matters where the president has influence and exercise power, not only on matters that will arise out of his direct, personal conduct. And I think that's a substantive matter that, in my view, needs to be debated, because I had few members reflecting on it, but the others were quiet. I'm not sure whether that being quiet means agreeing. And I would posit to say, if we go in that direction, we will have to be very explicit. What is that indirect conduct? Is it related to his office specific? Is it related to the functions of ministers or deputy ministers? How do you define that this indirect conduct? I'm saying that's one of the issues that have been raised, but I didn't hear other members commenting on it. And in my view, I don't think, all of us are clear about what will that mean. And I just thought I needed to flag it. The other one related to 129M, where members felt that President must be able to appear himself. And I just wanted to say, if you look at 129M3, it does say that the impeachment committee must afford the president the right to be heard in his or her own defense and to be assisted by a legal practitioner or other expert on his or her choice. I don't think it therefore follows that he will not appear. I just thought I needed to make that clarity on that one. On the issue that has taken us a bit longer, on the fit and proper, while everybody is agreed with the principle, I think the difference comes on definition, and I think the legal team have made their statement as to why they think there will be need for thorough, articulation on this matter. But also they do say that it's context specific, and that as it stands now, there's nothing very clear as it relates to members of the National Assembly. What will that fit and proper mean? But secondly, beyond just the principle, the other members are raising an important point of distinction also. Other members have said this is an important committee akin to the Committee on Intelligence and Ethics. And Honorable Nhlangwini correctly puts that if you look at those committees, particularly your Intelligence Committee has to go through vetting process. So members will supply the names, but those names will go through vetting, others will pass it, others won't pass it. So there's a particular determination as to how you arrive at those who serve there. And I think when we apply the fit and proper, one thing that is not clear is even when you make those determinations, who then does that determination? Is it the Speaker? Is it the House? Is it the Rules Committee? Who does it? And what is the kind of conduct that these members must possess that will be defined as fit and proper? So it's not just the simple of the principle, of a matter of a principle. It's being at one as this Rules Committee recommending to the House so that everybody understands exactly what do we mean about this new rule that we're putting that we must be subjected to if we serve in particular committees of the House. And I do hear members saying, no, let's put it, but we'll deal with it later. It's not quite clear, honorable members, when you say later, when. So it raises a new issue of retrospectivity, not just on this matter, so on the 129A subsection C. I think there's the point that Honorable Cholip was raising to say, if you then say we are just here, we're putting next time, so what was the point of having this meeting? And I do think, honorable members, if we want this rule to pass the litmus test, If we want these rules not to be rules that we fight around when it comes to implementation, better we clarify that. So my proposal and my summary is that the subcommittee on rules working with our legal team must actually meet as soon as is possible, define the fit and proper conduct for, and who actually makes that determination, so that when we approve this principle, we are all at one about what it means. Secondly, the issue of indirect conduct in respect of the president, it must also be clarified so that when we actually insert it or not insert it, but we are clear what do we mean, because it's a matter that has already been raised by other members of this committee who were saying, we are not happy that you are only limiting this accountability. We want it are not saying anything, agreeing or not agreeing, but I think it's a substantive matter that must go back for thorough canvassing by the sub-rules and legal team and be brought back to us, so that when we proceed to go to the House, we are clear collectively what are we recommending the House to deal with. And I would say the last matter that the sub-rules might deal with the legal team is the retrospective nature of the application of these rules. Thank you, Honorable Member. This is my summary in terms of how we move forward on these issues.
I support your summary, Madam Speaker.
Thank you. This
Madam Speaker, can I just ask for clarity, second question?
Yes, Honorable Mani.
Yeah, thank you, Honorable Speaker. Thank you for your indulgence. I just want to know what your summary means for the impeachment committee. In fact, in the sub-rules committee, I had argued that, and I don't want to be like bringing that argument here again, otherwise Honorable Mhlaude is going to raise on a point of order. The issue was that the Constitutional Court had actually made our life easier by giving us a read-in. Now, if we are saying what we're saying now, can we therefore also, Honorable Speaker, maybe can confirm this now as well, but it was stated on record that nothing stops the impeachment committee from proceeding. So I want to just get it clear once and for all that, and accept that all of these things that you said must happen in the manner you've outlined. But I would have a problem if all of those things will in some unintended way become matters precedent to anything that the impeachment committee must do. So if we are able to say, as things stand, until just like the court order had said, that up until this committee has done what you outlined. Can I just finish the point? Can I just finish the point? English is not my first language. Can I just finish?
But you have actually articulated the question that you wanted to ask. Unless there's something new, because this one I think you have motivated.
Yeah, I just want to make it clear, Chair. Sorry, I'm gonna sit down just now. Just to be clear that when we go back to the drawing board, the sub-rules committee and everything else, that the impeachment committee will proceed on the order of the court with the read-in, and this process that we must get engaged in will not in any shape or form be a precedent of or an inhibitor for the impeachment committee to do whatever it needs to do. That's all. I need to just make sure that we are clear on Speaker. Thank you.
Madam Speaker.
Honorable Chair.
Thank you very much. There is something that I want to understand so that when we leave here, we are all on the same page. There are detailed rules that as the subcommittee and some of the parties' inputs, because some parties didn't have the opportunity to make those inputs. Those detailed rules, we said the Rules Committee will have to take to send them to the Impeachment Committee, together with the framework of the terms of references and the inputs of all parties who serve in the Impeachment Committee. They will assist to enrich the terms of references in that Impeachment Committee. So now, as this committee has, the Rules Committee has is referring back the matter to the subcommittee. Is the subcommittee now going to deal, because some of the issues that were raised here are contained in the detailed rules, meaning that the members who are here, they haven't maybe gone through the detailed rules, which must be sent to the Impeachment Committee. So I just want to understand now, because when we go back to the subcommittee on rules, are we going to deal now with the inputs? Are we going to wait for the other parties to submit the inputs? I thought we were dealing with the technical rules as the subcommittee. So I want that clarity. Thank you.
Thank you very much, Chair of the Sub-Rules Committee. There are three matters that are referred to the Rules Committee, to the Sub-Rules Committee. And I've articulated them, relates to the definition of fit and proper for members of the National Assembly. Because as the legal team has said, is that there's a very general definition. If I were to read on the definition of Helen Suzman Foundation versus President of the Republic of South Africa, it defines fit and proper for appointment as the overarching requirement for suitability is fit and proper, which broadly speaking means that the candidate must have the capacity to do the job well and the character to match the importance of the office. Experience, integrity, and consciousness are all intended to help determine a possible appointee's suitability to be entrusted with the responsibilities of office concerned. Which is why the legal team said the term of fit and proper is context specific. And they said, at this stage, there is nothing that defines fit and proper for the members of the National Assembly. That is why I am saying that must go back to the sub-rule committee to actually clarify, so that we don't just accept a principle of fit and proper without the definition, but also its applicability. How would we and who will actually make that determination, such as in the setup of an IC committee? So that's one issue. The second issue relates to 121 AC, where there was a view from other members feeling strongly that the exercise of the president's power when he works, the charge must include not only what is directly specific to him, but also where he has an influence, and therefore indirect. And that's why I said other members canvassed this view that that rule 129A1C must be expanded, but others were quiet. I'm not sure whether that quietness means agreeing or what. And I'm saying it's a very substantive matter, because you will then have to say, if a minister appointed by the president does gross misconduct, will you impeach the president for that? Because that person has been appointed by the president in the work that he or she is doing. If a member of a statutory body behave in a grossly misconduct way, appointed by the president, does that revert back to the president? So that is why I said those two issues go back to the sub-rules, so that we are very clear as to what are we trying to say and what are we recommending to the House. In respect of the other rules, detailed rules, which I'm sure will be procedures and terms of reference by the IC, those are referred there. And my understanding is that that was your recommendation, that we do not deal with them here, but they are referred back for the detail to the impeachment committee, which is already set up and must define its procedures and processes. So all other parties, if they've got views on what has been circulated, they will actually deal with it in the impeachment committee. So I hope we agree in that respect. The committee has been set up, Honorable Manye, and its chairperson will determine when it meets and decide on how they deal with its program.
You covered, Speaker, more than
Honorable
enough.
members,
We agree.
agreed so that I bring this matter to a close.
Yes, we agree with you.
So Speaker, is effectively two matters that must go to the subcommittees, a fit and proper and section 1, and then 129A1C.
By briefing, you are delaying the meeting now. I will call
Thank
you
you
on
very
the
much, honorable members. Honorable Manye, I said exactly that. So we're not finalizing the rules today. Those two matters must be taken back to the sub-rules committee. And I hope it will deal with it with legal team expeditiously so. Thank you very much, honorable members. The meeting is adjourned.
Very good, Speaker. Long live the Speaker.